Seems reasonable, right?
Just, Your Honor, the fact that the statutes don't allow for a reply.
Okay, Holthus presiding. Please take a seat.
15 to 20.
Page 15, State of Nevada versus James McGrath, C379122-1. Page 16, State of Nevada versus Durward Hindle, C379122-2. Page 17, State of Nevada versus Jesse Law, C379122-3. Page 18, State of Nevada versus Michael McDonald, C379122-4. Page 19, State of Nevada versus Shawn Meehan, C379122-5. And page 20, State of Nevada versus Eileen Rice, C379122-6.
Good morning, Your Honor.
Morning.
Alyssa Engler, bar number 11940 with Matthew Rashbrook and Attorney General Ford on behalf of the state.
Morning.
Good morning, Your Honor. Richard Wright on behalf of Mr. McDonald. He's on Zoom.
Good morning, I'm Montaleve for Eileen Rice. I would request that her presence be waived for today.
Any objection?
No, Your Honor.
Good morning, Your Honor. Maggie McLetchie for Jesse Law, who is on the Sigal Chattah, line number 8264 on behalf of Shawn Meehan, who's also on Zoom.
Brian Harvey on behalf of Jim Hindle, who's also.
Also, Your Honor, George Colasas, I'm on the telephone for Mr. DeGraff and Reed.
Everybody?
Mr. Colasas is on Zoom for Mr.
Yeah, I said, is that, that's everybody then?
Yeah.
All right, this is a defendant petitioner's motion for leave to file reply.
Yes, Your Honor.
Anything to add? What do you want to say? Go ahead.
Only that, all we are simply trying to add in is documents that were in the possession of the state that we did not have at the time we filed our writ, which we contend are exculpatory and should have been presented. We're simply wanting to reply because we did not have them at the time.
Seems reasonable, right?
Just, Your Honor, the fact that the statutes don't allow for a reply, when we look at 34-700, the language is clear. It gives a time for a writ and a response, and that's
But
it.
there's nothing specifically not allowing a reply, is there? I mean, what's the harm in more information? If they received information they needed that was relevant to their motion or petition, what's the harm in allowing them to file the reply?
Because the state's position is that the statute is clear and that there is no need for it. And the burden of the reply is slight or marginal evidence, has the state met its burden of probable cause. And what they're trying to bring in, these 2 additional emails, are not exculpatory and they're not relevant to the
I'm not saying it's, what's the word?
Exculpatory.
Yeah, well, I'm not making a decision as to
Petition.
the petition itself or its impact or whether it's relevant or not relevant. All I'm saying is it seems fair to let them file it and for me to read it. I don't see the downside to that.
The statute doesn't allow for it. It doesn't specifically say it. When we're looking at interpretation, we have to look at the clear meaning of the statute. That's the state's position, and I'll submit it to you.
I mean, generally, I can ask for supplemental anyway and allow it, I think. Which brings me to my, so I'm gonna grant it. I don't know of any reason that I can't. I mean, I don't know, does that mean you want to reply to the reply, or are you?
We essentially.
I know there's no authority for that either,
No,
but
Your
I
Honor,
let you, I'm gonna let them.
Your Honor, in our response, we essentially argued our position on the exculpatory evidence, and there's like, we can submit it on our briefing as well, so no additional briefing would be needed.
Sounds good. I have a question for the state.
Yes.
I haven't seen something like this. This is different for me.
Okay.
And there's so much. And at least the initial motion to dismiss boils down to the jurisdiction and
Right.
what. I'm gonna ask you to do a supplemental and just streamline for me what ties, what actions occurred in Clark County that warrants us being in Clark, not everything else, just the actual facts that were presented to the grand jury, the statements, whatever it is, exhibits and everything. So Because I can't get, I mean, let's face it, the majority of this happened elsewhere, the way I'm reading it. It says,
It happened all.
did here in Clark County, Nevada. I'm just trying to figure out what exactly was here, if you could do that for me. I'll get you there. All right,
When would you like that briefing?
whenever you get, we don't have trial till January, right? So,
We don't, but our preference is to have these motions heard as soon as possible, so we can get that briefing to you as soon as your honor would like, so that we can get something on calendar.
no, I agree, because my guess is whatever I do, one of you is going to appeal me. So we can get up to the Supreme Court faster, I suppose.
And we reply to that,
To what?
their brief.
To their brief in opposition to your ability to reply?
No,
The
there's
supplemental.
Oh, well. You can reply to the extent that if she says exhibit A picture of one of the defendants here in Clark County doing something wasn't presented to the grand jury, you can correct the record.
Okay.
I'm not looking for more argument, guys. I'm looking for the facts. What exactly occurred here to give us jurisdiction here? That's all I want. I don't want anything else. I got a lot of other stuff. I just need the facts. Okay, so how much time do you want?
We can have it to you by next week.
Okay. 7 days, 10 days?
7 days is fine.
Okay.
Yeah, we can have it by 7 days. So, and if the court wants to set a hearing, we'll get it to you and defense in plenty
Okay,
of time.
I'm in a trial. I'll be in for the next 3 weeks, so no rush. I don't know that I'm gonna get to it right away, so if you want more than 7 days, take it, because I probably won't get to it.
Okay.
Or do you want to work backwards from the hearing date?
Yeah, I mean, that makes sense, if we just can get a hearing date. 7 days, 2 weeks, 2 weeks is fine. I think we'll be able to get it done in 2 weeks. So our preference is just to get the hearing date.
What are you looking at?
Your Honor, when we first started meeting and conferring based on the dates that was sent by your chambers, we had all come to an agreement of June 10th, which was on your Monday, Wednesday schedule. But
Okay,
I think we were told that that date might not be available for the court after we selected it. So
the Monday, no, the Wednesday we could do. Right?
Oh.
I do June 12th.
Well, Your Honor, if they get, if they're having 2 weeks to respond, I just want to make sure that we have enough time to respond to theirs.
We're gonna work backwards,
Okay,
so everybody gets something.
all right, so June,
Your Honor, I'm not here on June 12th. I apologize.
17th or 19th?
Either of those days are fine with the state.
Right, what's a holiday?
the 19th is a
Oh, that's
holiday.
the 19th is a holiday. It's Juneteenth.
Oh, 17th?
That's fine with the state.
I'm not, Your Honor, I've got an E&E up in Washoe on the 17th.
Can you zoom in?
I'm sorry?
Can you just
Yeah.
zoom in here? for a minute while we get
Sure,
it
as
done?
long as it's after 9ish, so I would assume 2 hours.
Yeah, we can,
The state's fine if the court wants to set it on the 11 o'clock schedule.
Your Honor, I have a conflict on June 17th that I had actually moved to accommodate a prior hearing and schedule this matter, and I can't move it again.
how about, how about the 18th? We do it at the end of civil calendar.
Yeah.
18th at 11?
It's fine.
Dude,
Your Honor, I have a pardons board meeting that day, and so I would have to be excused from the hearing that day.
Are you asking me to move it so you can be here or excusing you from?
No, I'd like this motion heard as quick as possible, and so if I'm to hang up, I will move out of the way. And so the 18th.
And we can fudge the time. I have my civil calendar starts at 10. we probably, I'm planning you guys 11, but if everybody wants noon or 1, as far as I know, we should be able to accommodate
Our
that.
board meetings usually last until 2 o'clock, so
You tell me, should I set it at the 18th at 11?
18th and 11.
That's
We'll
fine.
take 18th and 11.
Okay,
All right, there we go.
yeah,
Yes, yes, Your Honor, thank you.
sold. And now, working back, I need anything we're gonna have. Well, let's see. Do you want everything? So we on that 2 weeks. Let's go. Figure out, tell me how to, I want to do 2 weeks, 1 week, 2 weeks. On the hearing date. Would that work? I don't.
Well, 2 weeks would be the week of the hearing date. The last 2 weeks. That would,
I just want to have 2 weeks with everything in it. For us to look at.
it's only they're responding to just five. That's the 29th, then 2 weeks, 7.
All right, that's what we're gonna do. It's gonna be 2 weeks. I'm only giving you a week because you're not doing anything other than correcting the record. And then we get time to look at everything and pull it all together.
So for the response will be May 29th. The reply will be June 5th.
Supplemental. It's a supplemental.
And to be clear, Your Honor, this is Maggie McLetchie for the record. The neither brief is to include legal argument, just facts in both.
Correct.
And citations and then exhibits if necessary.
Yeah, citations to the grand jury.
Understood, thank you.
But yeah, no, this is just, I want it all in one place. I want to know
Yes, sir.
what I got.
Very good.
So supplemental briefing for the state.
Supplemental briefing for the state, 2 weeks. Opposition reply, what do you want to call it? I call it a reply?
For defense. 1 week for defense and then the hearing. And then the hearing will be June 18th at 11 a.m.
Thank you, Your Honor.
Thank you.
Thank
Thank
you.
you.
Have a good day,
Good luck
everybody.
with your trial.